Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hi everyone.
As we know, last week, Prince Charles delivered the Queen's speech, which was the first time Her Majesty missed the state opening of Parliament since 1963, some 59 years ago, when she was pregnant with Prince Edward. It was pleasing to many, monarchist or not, to see her attend the Royal Windsor Horse Show in such splendid spirits. Now, Dennis, you've been looking at the Queen's speech. What's in it of interest to local government?
Yes, Helen, I thought we should start with a brief canter through the Queen's speech. There's quite a lot of that, which will be of interest to our members. Here's the run-through. Standing in for the Queen, Prince Charles announced plans for 38 new laws, including a levelling up bill, giving local leaders powers to tackle decaying high streets. Local people will also be given powers to shape planning decisions in the new bill. A levelling up and regeneration bill will introduce a new locally set non-negotiable levy paid by developers to deliver infrastructure such as schools and new roads. Among other new laws will be a Brexit freedoms bill designed to make it easier to adapt carried over EU legislation. The existing data protection regime will be reformed by a new data reform bill. Public sector procurement law will be changed with the publication of a procurement bill designed to simplify existing legislation. Two new bills will revive long-delayed plans to ban no-fault Section 21 evictions for tenants. There will also be a social housing regulation bill designed to tackle rogue landlords. The government still plans to introduce constraints on legal challenges, and a new British Bill of Rights is intended, controversially, to replace the Human Rights Act. The proposed Bill of Rights will ensure there is a proper balance between the rights of individuals, our vital national security, and effective government, strengthening freedom of speech. Now, a curiously titled bill, the Boycott, Divestment and Sanctions Bill, will prevent public authorities such as councils from adopting their own boycott policies against countries that they disagree with. Two new bills, a schools bill and a higher education bill, will be aimed at improving the quality of education. The government will announce new offences to stop protesters from locking onto infrastructure, extend stop and search powers, and make it illegal to obstruct transport projects. The Public Order Bill will be aimed at quashing tactics employed by protest groups such as Extinction Rebellion. And following earlier announcements, a draft Mental Health Act reform bill will also be published. And finally, a transport bill will create a new accountability body, Great British Railways, which will have contracting powers for passenger services with goals and budgets set by government. So, Helen, that's a roundup of the government's main legislative plans. But between you and me, I strongly suspect there will be many controversies and diversions along the way that might blow this government off course. More standards and ethics issues, perhaps, and issues with compliance with the rule of law. What do you think?
Well, I think if you weren't lucky enough to hear Lord Evans at the opening of our LLG Leadership Conference last Friday, you really ought to get in touch and obtain our pay-to-view on-demand webinar. He really was tremendous to listen to, and of course, as chair of the Committee on Standards in Public Life, at the heart of ethics and standards. Now, turning to other matters, the Office for National Statistics estimates 1.5 million people in the UK are living with long COVID, and the severity of problems also varies enormously. Some people will have no issues continuing with their day-to-day lives, while others may struggle. The Equality and Human Rights Commission have produced a statement on long COVID, in which they say there continues to be discussion of the various symptoms related to COVID-19 that are often referred to as long COVID, and whether they would constitute a disability under the Equality Act. Given that long COVID is not among the conditions listed in the Equality Act as ones which are automatically a disability, such as cancer and HIV, we cannot say that all cases of long COVID will fall under the definition of disability in the Equality Act. This does not affect whether long COVID might amount to a disability for any particular individual. It will do so if it has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. This will be determined by the Employment Tribunal or court considering any claim of disability discrimination. To support workers affected by long COVID and avoid the risk of inadvertent discrimination, we would recommend that employers continue to follow existing guidance when considering reasonable adjustments for disabled people and access to flexible working based on the circumstances of individual cases. Sound advice indeed. And you can learn more about COVID in an employment context by catching up on our Employment National Lead meeting delivered by Alison Cook of VWV last Thursday, available now on our resource hub. So Dennis, I understand that you've been looking at some important housing law cases.
Yes, Helen. Homelessness is always in the news, and the courts have taken the opportunity recently to clarify aspects of the duty that councils owe to provide accommodation. Here's the story. In joined cases involving Birmingham Council and Croydon Council, the duty to provide homeless accommodation has now been clarified. The principal issue in the Birmingham case was the nature of the duty owed by local authorities to homeless persons under Section 193, subsection 2 of the Housing Act 1996. This provides that a housing authority shall secure that accommodation is available for the applicant. And the sole issue in the Croydon case concerned the circumstances in which a court may refuse a mandatory order to enforce a duty owed under Section 193, subsection 2. Now, Lord Justice Lewis said that Section 193 applies when certain criteria are satisfied, and that Section 193, subsection 2 defines the extent of the duty. He said that the duty, once owed, is an obligation on the local housing authority to ensure that accommodation is available. The duty is immediate, arising when the duty is owed. It is non-deferrable and unqualified. It is not to secure that accommodation will become available within a reasonable period of time. However, he continued to say that the duty to secure that suitable accommodation is available does not mean that permanent accommodation suitable for long-term occupation must be provided immediately once the duty is owed. Different accommodation may be provided at different times. What is suitable may change or evolve over time, depending on all the circumstances. What is suitable will depend on a number of factors. The court said that the duty, being by nature immediate, unqualified, and non-deferrable, does not impose, however, an impossible burden on local authorities. The requirement of suitability is liable to be affected by a variety of factors. In the longer term, it may be substantially more demanding than in the short term, when the local housing authority is responding to an immediate situation of homelessness. Now, housing lawyers will want to take a close look at this case report on the Birmingham case for more detail on other aspects of this important and indeed very topical issue.
Thank you, Dennis. Now, taking a look at the LGA Bulletin, schools that stay with their council are more likely to perform better than those who convert to an academy, according to research by the Local Government Association. Councillor Antoinette Bramble, chair of the LGA's Children and Young People Board, speaking to the Radio Times last week, said that the local authority has knowledge of local area, they know the communities, they know the families, they know and understand the geography, the businesses, what's happening in early years and prenatal care. They have that close relationship with the schools and sometimes interface with parents in a way that academies don't. In other academic news, GCSEs and A-levels will return to normal next year as the exams watchdog, Ofqual, announced it would drop COVID measures on coursework and practical tests in 2023. The watchdog told pupils last Tuesday that no adjustments would be made next year to accommodate the impact of them. I wonder whether it might have been prudent to wait for the Key Stage 1 results to give a formal gauge on how the younger pupils are performing and where the main impacts from COVID lay, and importantly, how long the effects will last in these age groups. There are certainly concerns about literacy across all age groups. Now, Dennis, turning to those local elections, You've highlighted the fact that a number of large areas are being reorganised. What's the detail?
Yes, some very large areas, mainly rural, have now been reorganised, or rather, the process has begun with a year-long transition phase underway. Now here's the story. We posted the full election results in Friday's bulletin, but this election was also about major changes in the structure of local government in some very large areas of the country. While these local elections were interesting for several other reasons, did you know that a new raft of large unitary councils has been created in shadow form and new councillors elected last Thursday? A vast swathe of district councils are now due to disappear around this time next year. So we now have new councils operating in shadow arrangements under the style of Cumberland Council, Westmoreland and Furness Council, North Yorkshire Council, and finally Somerset Council. Now these new large councils face numerous challenges. First, organisational, political and structural. Just how do they take advantage of their size and scale strategically while remaining effective at a local level? Second, there's the challenge of amalgamating county and district functions. And third, there's the human resource issues around appointments, staffing and redundancies. The coming months will be a stressful time for many in these new emerging authorities. Then there's the bigger picture. It should be noted that the unitarisation of local government has been both sporadic and piecemeal. Large areas remain two-tier still, so we can no longer speak of a uniform pattern or system of local government. Indeed, that has been the case at least since the reorganisations under the John Major government in the 1990s. But a number of important questions arise from this irregular and disjointed approach to structural change. First, what is the cumulative impact of this haphazard reform of local government? Different types of councils operate in different areas with no obvious pattern or logic. But does that matter? Some large towns, take Harrogate and Scarborough for example, will no longer be the seat of local administration. And again, does that really matter? And do people buy in or feel any affinity for these huge monolithic entities that have replaced them? And is there a democratic deficit created by these changes? Do people feel disenfranchised, or that their voice, their local voice, has been lost or diluted? And second, what is it like to be an officer in a shadow council area during the complex of diverse transformations that this must inevitably involve? Now, we would like to build a picture here at LLG of what it's like on the ground as the shadow year proceeds in these new authority areas. Get in touch with us with your views, or alternatively, if you're directly affected, share your experiences with us. Go to the forum page on our new website and tell us more.
And finally, the Freedom of Information Act does not permit aggregation of the separate public interests in favour of maintaining different exemptions when weighing the maintenance of the exemptions against the public interest, which favours disclosure of the information sought, the upper tribunal has ruled. Now, this is the matter of Montague and the Information Commissioner and Department for International Trade. It also determined an interesting and important second issue on whether information disclosed after a public authority's decision on a request, for example, during the Commissioner's investigation, in the course of first-day tribunal proceedings, or as a result of a tribunal decision, should be treated as in the public domain for the purpose of weighing the public interest test in disclosure of any remaining requested information, known far more helpfully in this case as the public interest timing issue. The upper tribunal concluded that it is to be judged at the time the public authority makes its decision on the request which has been made to it, and that decision-making time does not include any later decision made by the public authority reviewing a refusal decision it has made on the request. Now, this really is one of those judgments which requires a silent room and a cup of tea, and I'm more than willing to admit that's what I had to do. But if you found it second nature, why not apply for our Information Management National Lead, which is currently vacant? Just get in touch directly with me at helen@llg.org.uk. And on that note, that's it for another edition of the podcast. You can read more on the items discussed today and many more besides by going to bulletin number 17, available on the LLG website now. So it's goodbye from me.
And from me too.
Thank you for listening. Have a good week.